I want you to imagine a scenario that probably keeps global supply chain managers awake at night.
Oh, there are plenty of those.
Right. But picture this. You're running a successful manufacturing business. Production is ramping up, and you've just transferred this massive 50% deposit. Let's call it, I don't know, $500,000.
Wow. Okay.
Yeah. You wire it to a new, highly recommended manufacturing partner in Vietnam for this crucial, time-sensitive order. And the first week, communication is great. By week 3, emails slow down.
I can see where this is going.
Exactly. By week 5, it is complete radio silence. The goods are nowhere to be found.
Just totally gone.
Gone. So your pulse is racing. You pull up that standard bulletproof international contract you both signed, to see how to sue them, and your stomach just drops. You realize the document you signed is practically useless under local law.
Yeah, and the panic in that moment usually stems from the realization that cross-border enforcement, well, it isn't just about translating a document, it's about translating an entire legal philosophy.
Yeah. Which is terrifying when you've got $500,000 on the line.
Absolutely. I mean, operating across borders without understanding the foundational machinery of the jurisdiction, that's a gamble that routinely costs foreign businesses millions.
So that's exactly what we're doing today. We are drawing from a big stack of expert sources insights from Dedica Law, LTS Law, Conventus Law, Vietnam Law Magazine, plus broad overviews of the Vietnamese judicial system.
It's a lot of ground to cover.
It is, yeah. But our mission for this deep dive is to decode that legal landscape for you. We're going to uncover why standard business contracts often just, fall apart over there, the hidden landmines in multi-million-dollar M&A deals, and how you can actually protect your business in a really unique, rapidly evolving system.
Right. And to understand why that specific piece of paper failed to protect your $500,000 deposit, we first have to look at the foundational operating system of the country.
The operating system, I like that.
Yeah, we have to understand the judicial arena that's actually tasked with enforcing these commercial agreements.
So sticking with that operating system analogy, because I think it works perfectly here. If we look at the structure, the absolute bedrock of private commercial relations in Vietnam is the 2015 Civil Code.
Yes.
I like to think of the Civil Code as like a smartphone's iOS, right? It's the underlying architecture that makes everything function. And then you have these specific laws, like the commercial law or the housing law.
Or just like the individual apps.
Exactly, the apps running on the iOS. So if you open a specific app to handle, say, a real estate deal and it lacks a certain feature, or if the rules are just silent on an issue, the system automatically defaults back to the overarching rules of the iOS, the Civil Code.
That default mechanism is critical, right?
Yeah.
Because it means you're never operating entirely within a vacuum of just one industry law.
Yeah.
You're always anchored to the Civil Code.
Right.
But we also have to examine the broader realities of the environment running that software. So the legal system is governed by the 2013 Constitution, and it's led by the Communist Party of Vietnam. And the judiciary is nominally accountable to the National Assembly. Now, looking at external analysis, and we're just reporting this to give you the complete picture, the U.S. Department of State has criticized the system. They point out that the judiciary lacks independence due to the political vetting of judges.
Right, right. And obviously, we're just laying out the facts from the sources here impartially, so you know what the geopolitical lens looks like.
Exactly.
But at the same time, the government is making significant administrative moves to increase independence, right?
Yeah.
Like transferring local courts from the Ministry of Justice to the Supreme People's Court. And a very clear signal of this modernization happened recently. As of June 2025, Vietnam officially ended the death penalty for 8 crimes, including corruption and drug trafficking.
Which is a massive shift.
Huge. The system is visibly in motion. But let's unpack this. If the overarching structure involves, political vetting of judges, how does a foreign investor ever feel secure taking a multi-million-dollar dispute to court there? It seems counterintuitive.
Well, what's fascinating here is the sheer pragmatism driving the commercial courts.
Pragmatism.
Yeah. Despite that overarching political structure, the private commercial framework is intensely focused on market realities. Vietnam has positioned itself as this absolute powerhouse in the global supply chain, right? Attracting foreign direct investment is a top priority.
So they need foreign businesses to feel safe.
Exactly. The courts know that to maintain that flow of capital, they have to uphold commercial agreements and foster a predictable environment. They are highly motivated to enforce valid contracts. But, and this is a big but, the exact wording of your contract is your only shield.
Because they won't read between the lines.
No, they won't. They won't apply common law assumptions to save you.
Right.
They enforce exactly what is written.
Okay, so let's talk about those entry requirements then. How do you actually create a binding agreement in Vietnam?
So the foundational definition in Article 385 of the Civil Code is straightforward. A contract is an agreement creating, modifying, or terminating civil rights and obligations.
Sure, it sounds standard.
It does. But the specific conditions for a contract to even survive its creation are remarkably strict. Language is a prime example.
Oh, right. Like, you might assume two foreign companies doing business in Vietnam could just sign an English contract to build a factory.
And that assumption would completely invalidate the agreement in certain sectors.
Wait, really?
Yeah. While general commercial contracts can often be in English, construction regulations strictly dictate that construction contracts must be in Vietnamese.
Even if both parties are foreign.
Even then, if an American developer hires a Japanese engineering firm to build a facility in Ho Chi Minh City and they only draft an English agreement, that contract is fundamentally flawed under local law before a single brick is laid.
Wow. Okay, what else?
There's also the concept of privity of contract, meaning only the original parties are bound by it. Holding a third party liable is exceptionally difficult, outside of a few specific things, like certain insurance beneficiary setups.
Okay, but the mechanism that really caught my eye in the sources is how contracts become void.
Oh yeah, the voiding rules.
Yeah, so a contract can be invalidated if it was established to conceal another transaction, or if it violates prohibitory provisions, or if it's just physically impossible to realize the object of the contract.
Which all makes sense logically.
Right. But then there's this nuance that a contract is instantly void if it contravenes social morality.
Ah, yes. Social morality.
Yeah.
It's deeply embedded in the Civil Code.
To an outsider, that sounds like a massive, unpredictable loophole. I initially pictured it like a bouncer at a VIP club who can just kick you out for a secret dress code violation that isn't written down anywhere.
That's a funny way to look at it, but it's actually not that arbitrary.
Right, because looking at the actual mechanism, it operates much more like the unwritten rules of driving in a busy city.
Okay, I like that analogy.
Yeah, so you have the posted speed limits and traffic lights, the written laws. But then there is the local flow of traffic. If you aggressively ignore that flow, you're going to cause a crash, even if you technically thought you were following the signs.
The flow of traffic is a perfect way to understand it. The courts rely heavily on accumulated precedents to define what actually constitutes a breach of social morality. It's an evolving standard based on community norms.
It's not just a judge's whim.
Exactly. And this is exactly why having local legal counsel is non-negotiable. An international off-the-shelf template will never warn you that your specific business objective might cross an invisible cultural or legal line. You need an advisor who knows the unwritten flow of traffic.
So copy-pasting a standard international contract is basically walking into a trap. Let's dig into that. Why do so many foreign businesses lose money when dealing with local partners?
It almost always comes down to the trap of vague language. Things that work in a common law system but completely fail in Vietnam.
Right, like the classic clause, the party shall resolve disputes in good faith. I see that everywhere.
And in a U.S. or UK court, good faith has centuries of case law defining it. In Vietnam, that phrase is practically useless.
Because it's too subjective.
Yes. A Vietnamese court requires objective, measurable criteria. If you tell a judge the other party didn't act in good faith, the judge has no mathematical or structural way to enforce that.
And I imagine this vagueness creates the deposit dilemma from our opening nightmare scenario.
Oh, absolutely.
Companies wire 30 to 50% upfront to factories to secure a production spot, but they fail to write in specific inspection rights or clear conditions for a deposit refund or a rigid definition of a material breach.
And then the factory delays the order by 6 months, claiming supply chain issues.
And the foreign company has zero legal leverage to get the money back because delays weren't strictly defined as a trigger for a refund.
Exactly. But let's compound that problem.
Yeah.
Let's say you do clearly define what constitutes a breach. You then run headfirst into statutory penalty caps.
Oh, right. The 8% cap.
Under Vietnamese commercial law, contractual penalties for a breach are generally capped 8% of the value of the breached obligation.
Let's do the math on that because it is staggering. If I sign a $1 million contract and the factory completely fails to deliver, the maximum penalty I can hit them with for breaking the contract is just $80,000.
To the cap, yeah.
Even if I wrote a 20% penalty into my template to scare them into compliance.
The court just invalidates the excess.
Why is it so low?
It comes down to civil law versus common law. Common law systems use heavy, punitive financial penalties as a deterrent. But the Vietnamese civil law system is focused almost entirely on restitution, restoring the balance.
Making the injured party whole.
Right. You can still seek actual compensatory damages for proven losses, but the punitive penalty written into the contract itself cannot legally exceed that 8%. It's designed to compensate, not punish.
That completely alters risk assessment. A supplier might look at an $80,000 penalty on a $1 million deal and think, you know what, it's cheaper to break this contract and take a better offer.
They do the math too. And it gets darker when you look at the reality of litigation. The sources warn heavily about the illusion of winning.
Right, you could spend years navigating those caps, proving your damages, and finally securing a judgment, only to realize the company you sued has systematically emptied its bank accounts.
The logistical friction is immense. Translation costs, consular legalization of foreign evidence, travel, it all outpaces the recovery value. By the time the court issues a ruling, the local company may have ceased operations, changed its legal representative to stall you, or just dissipated its assets.
A victory against an empty shell company is worthless. So I guess the absolute best contract in Vietnam isn't one that helps you win in court. It's one that structures payments and specific milestones so securely that you never have to go to court in the first place.
Exactly. You engineer the leverage into the payment schedule, not the penalty clause.
Which brings us to an even bigger scale. Because assuming things work just like back home doesn't just ruin basic supplier contracts. It regularly destroys massive multi-million-dollar mergers and acquisitions.
Lack of proper localized legal due diligence is the leading cause of M&A failures in Vietnam.
Let's say you're acquiring a company in a highly regulated sector: banking, real estate, telecom. The compliance rules are incredibly dense.
Real estate is the perfect example of where foreign investors miscalculate. Vietnam operates on a complex property system. The land itself belongs to the people and is administered by the state.
Wait, so you don't actually buy the land outright?
No, not in fee simple absolute ownership like in the U.S. You acquire land use rights through leasing or allocation.
Okay, so if a foreign conglomerate buys a Vietnamese real estate development company, they might look at the balance sheet and see this massive portfolio of property assets. But if they don't verify the underlying land use certificates,
They might discover post-acquisition that the target company only had a short-term lease that's about to expire, or that the specific land allocation doesn't legally permit the construction of a commercial high-rise.
they bought a company for its real estate only to find out they can't legally build on the land.
It happens. And the risk extends deep into operational contracts, too. Investors frequently overlook change of control clauses.
Where a supplier can terminate their agreement if the company is sold.
Exactly. Imagine buying a thriving manufacturing plant. The ink dries, you take ownership, and on day one, the primary raw material supplier legally terminates their contract because ownership changed hands.
Your new expensive factory suddenly has zero supply chain.
Or you uncover undisclosed tax arrears and pending litigation that magically come to light the week after the funds clear.
Unbelievable. But the area where due diligence failures seem the most catastrophic is intellectual property. Let's say an investor buys a promising Vietnamese tech startup. They're paying a premium to own the software and patents.
They complete the acquisition, integrate the software, and only then discover that the key patents or trademarks were never properly registered with the Intellectual Property Office in Vietnam.
So they have no legal protection. It's the equivalent of buying this insanely expensive sports car, driving it off the lot, and only then finding out the engine block is leased and the tires belong to the neighbor.
It really is.
How do major international investors miss something as huge as a tech company not even owning its own software patents?
Because they rely on digital data rooms. They sit in a boardroom halfway across the world, looking at high-level financial statements. They take the target company's word for it. They avoid the grueling localized work of checking the physical intellectual property and land registries on the ground.
Right. The data room shows the intent, but the local registry shows the reality.
Exactly.
Okay, so whether it's a catastrophic M&A failure or a supplier taking a deposit and vanishing, what actually happens when the contract is broken? How do you fight back?
Well, the system categorizes breaches into specific tiers. You have a minor breach, a partial deviation. Say a shipment arrives a day late, but the goods are fine.
Yep.
Then you have a material breach. This is the critical threshold. It's a severe violation that completely defeats the fundamental purpose of the contract.
The sources cited a 2023 case to illustrate this concept. The rapper Florida won $82.6 million after a company failed to fulfill an endorsement deal.
Right, although that's a U.S. case.
Right. And we just established Vietnam focuses on compensatory damages, not punitive. But the core concept of a material breach is the same, right? The breach destroyed the purpose of the agreement.
Exactly. The framework also recognizes anticipatory breaches, where a party repudiates the contract before the due date, and fundamental breaches, which is a concept under the CISG. Vietnam signed the UN Convention on Contracts for the International Sale of Goods in 2017.
Okay, so when a material breach occurs, what are the remedies? I know there are damages, which cover actual loss and lost profits, and rescission, which cancels the contract entirely, and injunctions.
Yes, but the crucial remedy to highlight, the one that requires a complete shift in mindset for common law practitioners, is specific performance.
I was fascinated by this.
Unlike in common law systems where damages are the default, Vietnamese civil law readily allows courts to force a party to physically fulfill their promise unless it's impossible.
Wait, so in the US, a judge usually just says, pay them back for the computers you didn't deliver. But a Vietnamese court is more likely to say, no, you promised to build these computers, so get back in the factory and build them.
Yes, they prioritize the actualization of the agreement over financial substitution. And this raises an important question about how it changes negotiation dynamics.
Because it gives you huge leverage.
Immense leverage. If a breaching party knows they can be legally forced to complete grueling, unprofitable work, not just pay a fine, the non-breaching party holds all the cards in mediation.
That's a massive stick to wield before a lawsuit is even filed. So what's the actual roadmap if you find yourself holding that stick?
First, review the contract to ensure the breach is strictly defined. Second, document the breach with objective evidence. Third, formally notify the party. Fourth, try mediation or arbitration.
And commercial arbitration is highly favored by foreign businesses, right? Because Vietnam is a signatory to the New York Convention.
Yes, so arbitral awards are generally easier to enforce. If that fails, litigation is the final step. But time is critical. The statute of limitations is typically 3 years. Delaying action often results in the total forfeiture of your rights.
We've covered a tremendous amount of ground. To synthesize this for you, Vietnam is an incredibly lucrative and dynamic market. But succeeding there requires bespoke legal strategies, meticulous on-the-ground due diligence, and a deep respect for the local realities of enforcement.
Do not rely on templates or assumptions.
Exactly. But before we wrap up, I want to leave you with a final provocative thought. We mentioned Vietnam as a signatory to the CISG, the UN Convention for International Sales. But they placed a very specific reservation on it. They mandated that international sales contracts must be in written form.
Right. They explicitly rejected oral or purely informal agreements under the convention. It demands a strict written paper trail.
And that creates a fascinating collision course with modern technology. Global supply chains are increasingly moving toward automated smart contracts and blockchain agreements executed by code.
Oh, yeah.
So as decentralized code-based business becomes the standard, how will Vietnam's traditional requirement for strict written documentation adapt? Will a smart contract be recognized as a valid written agreement by a judge analyzing social morality and the civil code?
It is an unresolved tension. And it will likely define the next decade of cross-border commerce in the region.
It's something every forward-thinking business leader needs to watch. So the next time you're staring down an invoice for a massive overseas deposit, take a breath, step back, and ensure your legal architecture is actually built for the reality of the jurisdiction. Do that, and you won't ever have to wake up to that nightmare scenario.